Hello, everyone, and welcome. My name is Cassie Christopher. I am a professor of law at Texas Tech University School of Law, where I have been teaching legal writing in a variety of forms for several years now. I am eager to share with you some of the things that I have learned about legal writing. So my assumption is that most of you are first-year law students, although what I have to say is equally applicable to upper-level students as well. What I'm going to try to do is give you a taste of legal writing suggestions and truisms that are applicable in lots of different places. We'll talk about legal writing for your first-year legal research and writing class, so memos and that sort of thing that you're writing for your classes. We're also going to talk about legal writing for exams, and I mean law school exams, and it'll also be applicable on the bar exam as well. And my hope is that you'll be able to understand then how a lot of these truisms that we're talking about today will be applicable in practice. So today we will discuss several different things. We're going to talk about organizing your legal writing. We're going to talk about common themes, as well as some of those exam versus memo differences. We're going to spend most of our time today reviewing an example called Martinez versus Ready Realty. And then I will also provide you with some takeaways and writing tips at the end before opening things up for questions. So your legal writing class that you are taking this semester may use one of these many acronyms, and you've probably heard of IRAC, and your legal writing class may use CREAC or CRAC or CIRAC or CRUPAC or TRAC. There's a wide variety of acronyms that different folks use to articulate legal writing. Organization schemes, that is. So the important takeaway here is that all of these phrases rhyme, and they all rhyme for a reason, because all legal writing is organized in basically the same way. All of these are variations on a theme. All legal writing is going to start out with some sort of headline, either an issue or a conclusion or a thesis or something like that. It's going to articulate the rule. It may or may not have a section where you explain how that rule has been applied in previous situations, but it's definitely going to then apply the rule to the fact pattern that's in front of you and then reach a conclusion again at the end. So most of my emphasis today is going to be on that A section. That's where lawyers make their money, explaining how the law applies to our client situation. That's also where you make your points on law school exams. So that's where I'm going to be spending most of my energy today. So let's use our example. It's called Martinez versus Ready Realty. In this fact pattern that I'll review with you here, and I'll also acknowledge that I have adapted this particular fact pattern from a wonderful book called Legal Analysis 100 Exercise for Mastery by the authors Hill and Buchanan. So our fact pattern here that we're going to work with today involves Marisol Martinez. Martinez operates the vegan yoga sanctuary in a local strip mall. Martinez offers yoga classes and vegan nutritional counseling primarily on the weekends during the day. She would like to expand her business to include meditation, aromatherapy, and massage services, particularly on weeknights. The landlord, Ready Realty, has recently leased a neighboring space to the Country Time Dance Hall. On weeknights, the dance hall offers barbecue dinners and country line dancing. These evenings are very popular, and the dance hall customers tend to use every parking space in the lot. Martinez has complained to the landlord about the noise of the dancing, the smell of the barbecue, and the parking overflow. Martinez argues that her space is unusable for massage, aromatherapy, etc. during the dance hall events. In response, the landlord has installed extra noise-canceling insulation, requested the dance hall open windows during the dinner service, and designated parking spaces for each business, which admittedly the dance hall patrons tend to ignore. Martinez contends that these improvements are insufficient. So that's the fact pattern that we've received. You may have received something like this in your legal research and writing class as an assignment that you then need to write a memo on. This might be what a fact pattern would look like on a law school exam, and you need to analyze the legal issues that you see here. Or this might be a summary of facts that your client brings to you when you're in the practice of law. So we're going to talk about then legal analysis through that IRAC paradigm, or one of the variations on that IRAC paradigm. So let's articulate the issue that we're going to be discussing today is whether or not Martinez has been constructively evicted from her leased premises. So we all know what eviction is. Eviction is when the landlord says to the tenant, even though the lease is not up, I am requiring you to vacate these premises, probably against the tenant's will. That's an eviction. A constructive eviction, I'll just inform you right now, a constructive eviction is one where the landlord has created or allowed to exist a situation where the premises are completely unusable. They are deplorable for whatever reason, and the tenant has been constructively evicted from the premises. The premises are in such terrible state of affairs that the tenant functionally can't use the space and has been as if they have been evicted from the premises. So we're analyzing today whether Martinez has been constructively evicted from her leased premises because the Country Time Dance Hall has moved in next door. So whether or not you're writing for your legal writing class or a law school exam or out in practice, you'll need to identify what's the question you're trying to answer. So that's the issue. Now, you may want to articulate that as a conclusion at the beginning of your research once you know what the answer is going to be. So, for instance, a conclusion version of the same issue statement would look like this. Martinez probably has or has not been constructively evicted from her leased premises. And then you might add the word because, and then add a little summary there. So we need to start out with some kind of headline that identifies both for the writer and for the reader, what is it that we're analyzing? Where's the point that we're driving to as we're going to work through this memo? So start off with some kind of a headline, like an issue or a conclusion. So here are the rule statements that we're going to end up using in analyzing this question. So this is just what I said to you a moment ago with a little bit more detail. A tenant has been constructively evicted if the landlord has done something of a grave and permanent nature with the intent to deprive the tenant of the quiet enjoyment of the leased premises. So that's a more legal sounding definition of a constructive eviction. What we've done here is articulate the question, well, not the question, we've articulated the thing we're analyzing, that's constructive eviction, and the test that we or a court or anyone else could use to determine whether or not constructive eviction has occurred. So the rule statement here does not have anything to do with Martinez. It's an objective statement of the black letter law. There's no particular situation here we're analyzing. It's just a description of what's the test we'll use to analyze this question. So if you were using this rule statement in a memo, for instance, you would definitely need to add a citation at the end of your rule statement. So a citation to a case or a statute or wherever you found this particular area of law. On a law school exam or on the bar exam, you don't really need to worry about citations. That's not the sort of thing the exam is testing your memory of. So I've added here just this note in brackets that if this were a memo, you could add a citation here. So what are the most important parts of this particular rule? Well, it's these particular buzzwords. So we have constructive eviction, so constructively evicted. That's the question that we're analyzing. And the way we determine whether or not someone has been constructively evicted are there are two things here that we need to analyze. We need to discuss whether there's been a grave and permanent deprivation. So the tenant is experiencing something grave and permanent. And also we need to analyze the landlord's intent to deprive that tenant of the leased premises. I'll add one more rule here. The landlord's intent to evict the tenant can be inferred by the landlord's failure to remedy a grave and permanent condition. So we don't need to find that the landlord actively wants to make the place terrible, but if the landlord is aware that it's terrible and fails to do anything about it, we can infer then that the landlord has the intent to constructively evict the tenant. So again, here on an exam, you would not need a citation at the end of that sentence, but in a memo setting or a brief setting, for instance, you would definitely want to add a citation at the end of your rule statements. Okay, so in order to analyze whether or not Marisol Martinez has been constructively evicted, what are the things we need to analyze? We need to analyze those two elements. First, we need to analyze whether or not there's been a grave and permanent problem. And second of all, we need to analyze the landlord's intent with regard to that problem. Now, what we also need to do here is make sure we analyze both of those issues from each side, from Martinez's side and from the landlord's side. So I'm going to suggest that one way to make sure that we have checked all of those boxes is to draft topic sentences that articulate each side of each issue. Those topic sentences will then become the beginnings of each of our paragraphs where we articulate our analysis. So here are some topic sentences. We're going to need to argue from the point of view of Martinez that she was constructively evicted because the noise and the smell and the parking issues constitute a grave and permanent deprivation of the use of the leased premises. On the other hand, we also need to argue from Ready Realty's point of view that the noise and smell and parking issues do not rise to the level of grave and permanent deprivation. So that's the two sides of the grave and permanent issue. We also need to analyze from the Martinez side that the landlord's failure to remedy the noise and smell and parking problems demonstrate an intent to constructively evict her. We need to argue the flip side of that as well. From Ready Realty's point of view, Ready Realty is going to argue that its efforts to resolve Martinez's complaints demonstrate that it did not have the intent to constructively evict her. So I've gone ahead and crafted these 4 topic sentences to make sure that I've analyzed everything that I need to. It's all of the issues from each relevant point of view. Each of these topic sentences incorporate the legal issue. So constructive eviction, grave and permanent, constructive eviction, landlord's intent. And then I've also made it clear from each of these sentences which point of view I'm analyzing. So what's the conclusion that each side here is going to argue? In these example sentences, I have included a few facts, namely the noise and the smell and the parking issues, to help both me and the reader remember, like, what are the details of this particular fact pattern that put this particular question in play. Okay, so let's start with our first topic sentence. So the topic sentence that I have here, Martinez will argue she was constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. And maybe you can see I've grayed out the rest of our paragraph here just so we can focus on the topic sentence for a second. The topic sentence, again, is articulating the legal issue and the point of view, or in this case, the conclusion that this paragraph is going to come to. This paragraph is going to articulate the arguments on behalf of Martinez that she was constructively evicted. So here's the rest of the paragraph. Let me read the whole thing to you, starting with our topic sentence again. Martinez will argue she was constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. The nature of Martinez's business, it's a vegan yoga studio, requires a level of peace and quiet, which means that the noise of country line dancing next door impairs her ability to use the space during the dance events. The barbecue smell is particularly unpleasant to Martinez's vegan clientele, and the fact that the smell of barbecue can linger for many hours after an event means that the vegan yoga studio will be unusable to its customers, not only during the dance events, but afterward. The noise and smell will effectively prohibit Martinez from using the leased premises for significant portions of the week, which is a grave deprivation. The fact that the dance hall customers park in Martinez's designated spaces likewise prohibits Martinez's customers from accessing the space during dance hall events, which is the precise time Martinez is looking to expand her business. Although the dance hall's weeknight events leave other times of the week available for yoga classes, the fact that the dance hall will continue having events every weeknight for the foreseeable future means that the deprivation is ongoing and permanent. So what I've tried to do in this particular paragraph is articulate which facts are legally relevant and why they're legally relevant. So this particular paragraph shows not only did I see this particular fact, but I understand how it could be argued that this particular fact is grave and permanent. So for instance, in our second sentence, I'm saying the vegan yoga studio requires peace and quiet. Therefore, the noisy dance hall next door is going to ruin the use of the space during the dance hall events. So you can see I've identified that this is an exam format. I'm just showing which facts here are legally relevant and the legal significance of those facts. There are no cases here. So this is an exam setting in an exam in law school and on the bar. You're not really expected to use case law. So there's no compare and contrast here with any precedent cases. Now, on the other hand, if this was for a memo for your legal writing class, you would want to include compare and contrast case law. So let me just identify here a couple of spaces, and they're highlighted, where I've added in some case law. So the topic sentence is exactly the same. Martinez will argue she was constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. And I've added this sentence. Just as the insect infestation in Applegate made the residential apartment unfit for its intended purpose, so the nature of Martinez's business, a vegan yoga studio, requires a level of peace and quiet. And we do include a citation to Applegate and connect those facts together. The noise of the country line dancing next door impairs her ability to use the space during the dance events. So let me back up for 1 second. Because I'm focusing on the application section, the A section of a legal analysis, I haven't included the paragraph before where in a memo for legal writing class, for instance, you would have summarized the Applegate case. I've skipped over that step for our purposes here today. But what's important to notice here is that even if this was a memo and I did have a previous paragraph where I summarized the Applegate case, I need to bring the Applegate case into the application paragraph. And I'm doing that by including the specific details of the Applegate case that are legally relevant and showing how they're similar to, not different from in this case, similar to our client's case. Similarities between the precedent case and our facts suggest that the outcome should be the same. So in Applegate, it's pretty clear from this sentence, in Applegate, there was a constructive eviction because there was an infestation in a residential apartment. So because of the similarities then, this case should also, Martinez's case that is, should also be found to be a constructive eviction. Later on in this paragraph, I'm going to use another case as well. So this is later on in the paragraph where I'm talking about the dance hall customers park in Martinez's designated spaces, prohibits Martinez's customers from accessing the space during the dance hall events, which is the precise time Martinez is looking to expand her business. This takeover of the sole parking lot is different from the P&L case, where one of 5 parking lot closures did not affect customers' ability to reach the tenant's store, and I would include a citation here to the P&L case. So again, if you had an E paragraph in your legal writing memo, you would have summarized the P&L case, but it's not enough to just leave it stranded in the E section. You have to bring the cases into the A section. And so here I'm articulating the specific facts from P&L and the outcome, and demonstrating in this instance the situations are very different, which is why the outcome should be different. So even though in P&L there was no constructive eviction, our facts here are different enough to suggest that there should be a constructive eviction. Okay, sounds good. Let me show you the same versions of this same paragraph that are not as effective. So for instance, now I'm going to show you a version of the paragraph that does not have enough specific facts from the fact pattern. It's the same topic sentence. Martinez will argue she was constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. Martinez's business requires peace and quiet, and the dance hall is too noisy and smelly for her customers to do yoga. Her customers cannot use her parking spaces. She has been constructively evicted. None of that is wrong. It's all accurate. It's all right. That is the argument. But there are not enough specific details here for the reader to understand exactly why this is the outcome. So Martinez's business is not specified here. What is Martinez's business? There's a reference at the end of that sentence. Well, it's a yoga something business. But Martinez's business requires peace and quiet. It doesn't tell us why is peace and quiet more necessary for Martinez's business than any other business. The dance hall is too noisy and smelly. It doesn't tell us what is the noise, what is the smell, why are those problematic for the yoga studio next door. The customers cannot use her parking spaces. It doesn't tell us why they cannot use her parking spaces, what the problem is, how often the problem occurs. Those are all details that help the reader understand, have that scene crystallize in their head. So if, for instance, we were to say instead, the smell of barbecue is infesting, floating across into a vegan-themed business. All of a sudden I realize, like, oh, that does sound really unpleasant for that vegan business. Whereas if we just say it's too noisy and too smelly, that's not enough information for the reader to really understand why this outcome needs to be the way that it is. Okay, let me show you another example of a weakness. This is a paragraph that has facts only. There's no legal significance demonstrated here. Martinez will argue she was constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. That's our same topic sentence again. Martinez's business is a yoga studio. The country line dancing is noisy. The barbecue smell is unpleasant to Martinez's vegan clientele. The dance hall customers park in Martinez's designated spaces. The dance hall events happen every weeknight. Again, there's nothing wrong here. All of those facts are accurate, but they're simply facts that are recited instead of the legal significance of them being clearly shown to the reader. When we just sort of group the facts together, we've done some of the work for the reader, but we're leaving it up to the reader to figure out how do these things fit together and why do all these things add up to a constructive eviction. So the dance hall events happen every weeknight. Well, so what? Your reader is thinking. Instead, we need to say the dance hall events happen every weeknight, which means this is an ongoing problem, which is grave and permanent. So we're going to connect the fact back to the legal conclusion that we're trying to reach. Let me pause for just a minute to say, whether or not you're writing for your legal writing class or a law school exam or the bar exam, there's going to be this instinct to not get specific about the particular facts because you figure like, well, the person I'm writing for knows the facts. They've already read the facts. Probably they wrote the facts. That's often the case. So I don't need to recite them because they already know what the facts of this case are. And that's not exactly why we're writing an exam. You're not writing an exam to genuinely inform a law professor of what the content of their question is. Like they did write the question. They know what the legal issues are. The purpose of this writing is not actually to teach them what the legal issues are. The purpose of a writing in law school is to demonstrate to the professor that you know what the legal issues are, that you can spot the legally relevant facts, that you can connect those legally relevant facts to the test, to the legal standard, and to a conclusion, to an outcome. So although it seems on some level kind of silly to parrot the facts back to the person who wrote them, what you're doing actually is demonstrating that you can identify the legally relevant facts, connect them to the existing law, and reach a legal conclusion. So we do need to be as specific about the facts and about how they connect to the law. Again, in a memo setting, you would definitely bring in case law to show similarities and differences. On an exam setting, you probably don't need to use case law at all. Okay. Here's another version. This is the original paragraph that I showed you, although without any cases. And I've highlighted some of the words where I'm doing that work, where I'm showing the connection between the facts and the law. Well, I'll just read it again one more time. Martinez will argue she was constructively evicted because. The word because is a magical word. Because the noise, smell, and parking issues, so those are facts, constitute a grave and permanent deprivation. So here, the word because is connecting some facts to the legal conclusion. Constructively evicted because the noise, smell, and parking issues constitute a grave and permanent deprivation of the use of the leased premises. The nature of Martinez's business, it's a vegan yoga studio. That's just a fact. She runs a vegan yoga studio. Requires a level of peace and quiet. So here I'm demonstrating the natural result of this particular fact. So what's the implication of this fact? A yoga studio requires a level of peace and quiet, which means that is the magic language here, which means that the noise of the country line dancing next door impairs her ability to use the space during the dance event. So I'm connecting the need for peace and quiet with the noise next door and connecting that to the idea of a constructive eviction. Next, the barbecue smell is particularly unpleasant to Martinez's vegan clientele. And the fact that the smell of barbecue can linger for many hours after an event, that's again the implication of the fact, barbecue smell tends to hang around for a few hours afterwards, means that the vegan yoga studio will be unusable to its customers, not only during the dance events, but afterwards. So again, I'm demonstrating the significance of the fact and connecting it back to the law and gesturing toward the constructive eviction problem. The noise and smell will effectively prohibit Martinez from using the leased premises for significant portions of the week, which is a grave deprivation. So here I'm explicitly connecting that back to that magic language from the topic sentence, a grave deprivation. The fact that the dance hall customers park in Martinez's designated spaces likewise prohibits Martinez's customers from accessing the space during dance hall events, which is the precise time Martinez is looking to expand her business. So I'm showing the significance of these facts again. Although the dance hall's weeknight events leave other times of the week available for yoga classes, the fact that the dance hall will continue having events every weeknight for the foreseeable future means that, and here's my legal conclusion, the deprivation is ongoing and permanent. Okay, so that's an exhaustive analysis of our first topic sentence. So here, remember again, what we're doing here, we're articulating both sides of both issues. So that means 4 different paragraphs analyzing these 2 particular issues. So we've talked about Martinez's point of view from the constructive eviction, from the grave and permanent issue. Next, we'll go through Ready Realty's response to that grave and permanent issue. And then we'll take a look at both sides' arguments regarding the landlord's intent paragraphs. Okay, so here's grave and permanent from Ready Realty's point of view. On the other hand, which is a magical transition phrase, on the other hand, here's our topic sentence. Ready Realty will argue the noise, smell, and parking issues did not rise to the level of a grave and permanent deprivation. Ready will contrast this situation with Applegate, where the infestation existed 24/7, to argue that none of the 3 issues is permanent because they only occur on weeknights, which is not Martinez's busiest time. And again, if this was a memo, because we're using case law here, we would definitely need to include a citation to Applegate. As compared to Nouse, a different case, where a varnish smell that lingered for 4 to 5 days was not considered grave and permanent, the smell of barbecue for a few hours a night also cannot be considered grave and permanent. The barbecue smell only exists for a few hours, and barbecue is a far more pleasant smell to the reasonable person than varnish. The fact that Martinez's customers are uniquely sensitive to the smell of meat does not mean the smell rises to the level of grave and permanent. Likewise, the fact that Martinez's customers may have departed further away from the studio does not rise to the level of grave and permanent, just as the court in P&L held that the closure of one of 5 mall parking lots was not a constructive eviction of the tenant. And we would include citations to all those cases throughout. So what I've tried to do with this paragraph is articulate again, what are the specific facts from the fact pattern? How are they similar to and different from the case law? And what's the legal significance of them? How do these facts connect to our legal conclusion? Let me also note, again, we don't have an E paragraph here where we've summarized these cases, but I've brought the cases into the A paragraph by telling you specifically about the case and what you need to know about it to understand how it's similar to and different from. So in the Nouse case, all you know about the Nouse case is that there was a varnish smell for 4 to 5 days, which was not grave and permanent, which frankly, for our purposes in this paragraph, is all you need to know about the Nouse case. So that's why those are the only details that are there, that are included. Okay, this is the landlord intent paragraph from Martinez's point of view. Martinez will argue the landlord's failure to remedy the noise, smell, and parking problems demonstrate an intent to constructively evict her. So again, that's a topic sentence identifying the point of view and the legal issue that we're analyzing and pointing us toward the conclusion. She will argue that the landlord's solutions to her complaints have not been sufficient. Despite the insulation, she can still hear the dancing. Despite the open windows, she can still smell the barbecue. And despite the parking signs, dance hall patrons continue to take up her parking spaces. Martinez will cite Applegate, where a landlord's inability to address an infestation problem meant that the problem continued and the tenant was constructively evicted. Despite Ready Realty's efforts, the problems remain and Martinez is effectively forced out of her leased space on weeknights, resulting in a constructive eviction. So I think you can see, again, I'm using specific facts here. I've brought in the case. Importantly, one of the things I'd like to point out here is that I'm ending this application paragraph not by talking about the Applegate case. I'm ending each A paragraph sort of reiterating the topic sentence. So I'm illustrating in the final sentence of each paragraph that, again, I've come back to this legal conclusion on this issue from this particular person's point of view. Lastly, landlord intent. Ready's going to make the argument. On the other hand, here's our topic sentence. Ready Realty will argue its efforts to resolve Martinez's complaints demonstrate that it did not intend to constructively evict her. Just as in Nouse, where the landlord redirected mall foot traffic to avoid blocking a restaurant's entrance, and here we have a citation to Nouse, so here the landlord has made reasonable changes to the leased premises so that both tenants can use and enjoy the space. The landlord has installed insulation to reduce the noise problem, requested the dance hall open the window to increase ventilation on barbecue nights, and provided designated parking spaces for each business. Unlike Applegate, where the landlord's complete unresponsiveness to the tenant's complaints constituted a constructive eviction, here the landlord's prompt attention and action regarding Martinez's complaints negate the argument that it had the intent to constructively evict her. So again, specific facts. Here, this is an A paragraph that we would use like in a memo for our legal research and writing class, so there are cases involved. Similarities and differences to the cases are articulated and the legal significance is explained. The paragraph starts off with a topic sentence showing what this paragraph is doing. This paragraph is making the landlord intent argument on behalf of Ready Realty, and the paragraph ends reiterating that conclusion that Ready Realty is going to say that there was absolutely no intent to constructively evict her. So we've just worked through in some detail all 4 of the paragraphs that we would use to analyze both sides of the 2 issues present in a constructive eviction question. And I hope you've been able to see how the writing is very similar, whether it's on an exam or on an office memo for your legal research and writing class. We tweak it a little bit with the inclusion of the cases or not. Obviously, when you're writing for your legal writing class, you have more opportunity to revise and refine. Some of those sentences got a little long. Some of them could have been reworded, that sort of thing. On an exam, there's less time for those sorts of issues. And so there's a little bit more leeway given for proofreading errors and that sort of stuff. But so we've worked through all 4 of these topic sentences, which guided the content of each paragraph. Let me give you just a few takeaways here, and I'll give you some writing tips on the next slide. It's really important for you to articulate both sides of each issue. Please don't rush to judgment. When I present this problem to my law students here at Texas Tech, oftentimes people's knee-jerk reaction is either she was constructively evicted or she wasn't, and they only want to argue that one side. It is important to pace yourself and be sure that you articulate both sides of each issue, even if you are pretty confident that one of them is the winning side. Be sure to articulate the other side of each issue. Those topic sentences that I've given you, that I've demonstrated here, including both the law and the conclusion or the point of view, guide both the writer and the reader. So if you're starting out with a writing project, drafting those topic sentences first, make sure that you, the writer, are going to analyze each side of each issue. And those topic sentences can guide you. So if you get sort of caught up emotionally in one side or the other, the topic sentence can be there to remind you, oh, right, I have to articulate the other side's argument as thoroughly as I can, even if I think it's ultimately not the winning argument. I'm also going to implore you to include the relevant factual details in your paragraphs. Don't assume the reader already knows them. Demonstrate here that you saw those legally relevant facts, that you have an opinion about how they're legally relevant and how they get to the conclusion that you're reaching. Lastly, some writing tips for you. Please use legal terminology without fear of being redundant. You may have noticed how many times I use the phrase grave and permanent. Grave and permanent is the phrase that the courts have used to discuss these issues. And so I did not try to find synonyms. I did not use words that sound similar to grave and permanent. Like I didn't say serious and ongoing, because that's not the words that the courts use to analyze these issues. They use the phrase grave and permanent. I'm going to use the phrase grave and permanent. There's not a problem about being redundant when you're using the actual legal terminology. Next, as I've indicated, the level of formality in the writing, whether or not you use citations, etc., depend on the audience, the purpose of the writing, how long you've been given to write it, that sort of thing. Take-home exams might have a higher expectation of formality and citations. Timed in-person exams would have a lower expectation of formality. I'm also going to encourage you to write early and often. We've spent some time here together today talking about how to write a memo or how to write an exam. And it's sort of like me explaining to you how to ride a bicycle. You actually don't know how to ride a bicycle until you've done it yourself a few times. So I would encourage you, the same with legal writing. If you haven't yet started, go ahead and do so. You're going to fall off the bicycle a few times. Better to do that earlier rather than later. So practicing your writing early and often. You're going to make a lot of mistakes, but you're going to make a lot of headway as well. And so you want to give yourself as much time and space to become a great legal writer by starting early and writing often. For take-home assignments, please, 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 as a professor, I'm begging, leave plenty of time for proofreading your work. I say this to my students, and I'll say it to you. An office memo that looks clean and makes an ordinary argument will get a better grade than an office memo that's brilliant and looks like a hot mess. So please make plenty of time for proofreading. For exams, when there's not as much time for proofreading, my advice here is to keep your sentences short. Clunky writing on an exam is okay, but keeping your sentences short tends to help you avoid making those kinds of typos, etc. I'll also mention the only typo that really matters on an exam is including the word not where you didn't mean to, or leaving out the word not when you meant to put it in. That's a really bad typo. Everything else is pretty forgivable. So with that, I'll stop sharing my screen and ask, what questions do you have for me about legal writing? Want to give me a thumbs up if you're currently working on a memo for your legal writing class?
I have a question.
Sure, absolutely.
Sorry. No, okay. So we are working on a memo, and there has been discussion, inconsistent discussion, about in our rule paragraph, which cases to include. Like, do we include, if we mention a case in our analysis, every case that we mention in our analysis should or should not be in our rule paragraph, not our rule proof paragraph, just our rule paragraph.
Got it. So, I mean, obviously, if your particular audience member has a very strong feeling about this, you should write for your audience.
Okay.
That's true in law school when you have an audience of one for each of your classes for the most part. This is true in practice too. You know, if you're writing to judges and justices, you write for them specifically. You learn their particular preferences and bugaboos, and you write for that audience member. So if your professor has a strong feeling about the answer to this question, by all means, you should do that. My own feeling when I teach legal writing is that I don't necessarily need every case that's in the rule proof paragraph or in the application section to also be in the rule paragraph, because all the cases that you mention in your rule proof and your application are about the same topic. So they've all got the rule included in that opinion. I don't necessarily need every single one of those case names to be in the rule paragraph. But if your professor feels differently about it, please do it the way they want to.
Okay, thank you.
Sure thing. I saw some thumbs up for folks who are working on their memos. Are we suffering? It's usually pretty awful the first time through. Adrian's laughing at me. If you're currently suffering through your 1L memo, what's the worst part about it? Can you articulate, like, what's the biggest problem that you're having?
So I will say for me, it's just making sure I'm not overthinking and making sure that I'm answering the call to question and not drifting off. But this helps a lot. Thank you so much.
Yeah, you're welcome. I'm glad it's helpful. I find that a good topic sentence can solve a lot of problems, to be perfectly honest with you. And I think that can also help you from wandering sideways. So you take your topic sentences and your the organization of your application section is probably driven by the rule itself. So if the rule has 3 elements, then you're going to have 3 paragraphs or 6 paragraphs or however you end up, organizing it. So drafting those topic sentences in accordance with the rule forces me to stay on topic, to make sure everything in that paragraph is talking about that topic sentence and that there's nothing extraneous. Or if I find myself talking about something that's not in the topic sentence, I can stop and ask, should I add this to the topic sentence? Does the rule justify me adding this to my topic sentence and to my analysis? So let the organization of the rule guide your analysis section. And also, we read the cases to see how other lawyers have talked about this issue. How have previous judges and lawyers analyzed questions that look like mine? And you can borrow that organization into your application section. So if the cases that you've read do not go on the particular tangent you're tempted to go on, then I think that's helpful information. Okay. On the other hand, oftentimes opinions talk about issues that are not really at play in your situation, so you don't need to analyze them. But part of the reason we read the cases is to see, how do other lawyers analyze this issue?
Okay, thank you so much.
You're very welcome. Sure.
I agree. I really enjoyed the topic sentences, the way you structured that. It does really help keep you in line with what you should be talking about for a paragraph. So I appreciate that very much.
Yeah, absolutely. I made an observation on Twitter. Well, it's X now, but I made an observation on Twitter once about, like, the more I teach legal writing, the more I think topic sentences are the answer to most problems. And somebody put, like, kind of a snarky response, like, I mean, maybe for the tired reader. And I was like, we are all the tired reader.
Yes. Yes, for sure.
Right.
I was gonna ask, I know one thing I struggle with as a 1L. I'm sorry, I was trying to ask earlier, but I got kicked out of the meeting. I don't know exactly what happened. But at what point should you stop, like, doing the research portion of it? Like, when do you feel like you've kind of, like, found all the cases you can find, and it's like, how do I know to stop doing that and just go ahead and start writing?
Yeah, this is the $64,000 question. I mean, how do you know when you're done researching? I don't think you'll ever feel comfortable that you've read it all. So you kind of have to let go of that particular benchmark. Like, I feel really confident now, and I'm going to move forward. Instead, the things that we look for are, are you seeing the same things over and over again as you're doing your research? Are you seeing the same cases pop up? Are they all referencing one another? Have you read all the cases whose names you have found? That's a good sign that you've got all there is. So the difficulty, of course, is that there's no case out there that's going to tell you exactly what the answer is for your situation. And that's sometimes we feel like we need to keep doing research because I haven't found a case that's close enough yet. I'm still looking for one that's a little bit closer to my fact pattern. But the reality is nobody hires a lawyer if there's a case already out there that tells us what the answer is. They only hire a lawyer because they don't know what the answer is, and reasonable people are disagreeing about what the answer is. So as a researcher, you do the research until you feel like you've got a grip on the area of law, and that's the time to stop and then to start writing, even though it feels like working without a net. Can I also kindly, supportively, respectfully request that at some point, I think in your heart of hearts, I am procrastinating by doing more research. And that is also a sign that you should stop and just start writing.
Very helpful. Thank you.
Yeah, absolutely. Anything else I can help you troubleshoot about your legal writing? Sure. Jalen, go ahead.
Yeah, so my question is, and I'm actually a 3L, and when it comes to writing a response for bar exam, for example, or like or a law school exam, do you see the benefit in outlining and then going in and filling in the blanks for the outline? Because I understand we're just on a big like time crunch, and I wanted to make sure I'm like for producing quality writing, but also staying within the parameters of my allotted time.
Sure. Can I ask a clarifying question? When you say outline, do you mean outlining as you prepare for the exam, like outlining in the weeks leading up to the exam, or outlining during the moments of the exam, like you have an hour?
Outline during the moments of the exam, like
yeah,
you read the fact pattern, look to call the question, and then start your outline. Because that professor said, "Wait, don't waste your time doing that." Ask the professor, said you should do that, and like I just wanted to kind of get your perspective.
Yeah, thank you for that question. It's an excellent one. I am wholeheartedly team outline. I think, in fact, that on a closed book exam, well, on an in-person timed exam, you should spend a third of the time outlining your response, like reading the fact pattern, figuring out what you're going to say and where it's going to go, and then you spend the second 2/3 of the time doing the typing part. So bar exam essay questions are 30 minutes long, so I counsel students to spend 10 whole minutes reading the fact pattern and organizing their answer. On an hour-long exam, that would be 20 minutes. Just spend the whole time, spend those 20 minutes reading the fact pattern, making notes for yourself, and organizing your answer. I encourage you to do it on the screen because you can then turn those bullet points into sentences and they're already in the right order that they need to be in. But that organizing time, particularly if you can use this topic sentence method and write down for yourself, like, this is the paragraph where I'm going to analyze the plaintiff's side of this issue. Then your next bullet point is the defendant's side of the same issue, and then moving on. What I think that does is a couple of different things. It organizes your thoughts. It helps you figure out how much do I need to talk about during this 2/3 time of typing, and where will I put all that effort? So for instance, on the bar exam, there are sometimes multiple calls of the question. So let's say there are 2 calls of the question. And if you don't outline, you just start answering the first question, and then you suddenly realize there's a second half of the question, and you might discover the second half was actually much more complicated, and you've just spent a whole lot of time on the first one. So what you can do during that organizing time is to figure out how much of my writing time do I need to spend on each component of the answer. It also prevents you from going off on rabbit trails, because when you're just I call it typing by the seat of your pants, and I think you know what I mean by that. Typing by the seat of your pants, you often end up going sideways, and you're 10 minutes into a paragraph and you realize, like, oh, this isn't relevant at all. And the 10 minutes or the 1/3 of the time that you spent organizing your answer help you identify, like, what are the most important things I have to say during the typing time, and I'm going to make sure I get those points down on the page before I add anything extraneous. So yeah, I'm a huge fan of organizing before you start writing. And if you don't believe me, I am going to beg you to practice it 3 times before your exam. Earlier is better, obviously. Like, if you want to find some practice questions this week, just try it 3 times and see if you buy in, because I think you'll find that you end up getting a lot more points points as in ideas laid down on the page, which will then translate to more points on the grader's rubric.
Awesome. That was really helpful. Thank you.
Sure thing. Happy to.
Yep, she gave us that method last year, and I've stuck to it since, and it's made like taking exams for me, like the 4-hour exam, like breaking it up time by time. I have allotted myself X amount of time to get like my writing done and my organizer done. It makes the actual exam less stressful because you're able like to see all your ideas first and then go back and write and kind of prioritize levels of importance, because the professors telling themselves by identifying what they want to hear about the most in their call, their question. You know what I mean? So I know if I miss like that last little piece of like, that's only gonna be like 1 or 2 points. But if I get the bulk of this issue done and outlined and think through all those processes, especially on closed book exams, I find that it works effectively for me to be able to use that organizer method, especially on like final exams.
Yeah. If I could just add, I remember one of my law school classmates during after our criminal law final, she revealed that she had spent a whole lot of time analyzing the speeding issue in the fact pattern that we had all seen, because somebody was speeding while they were driving, and everyone else was like, "Didn't you talk about all the homicides?" Like, that's where the points were, not in speeding. Anything else I can help troubleshoot? What's the most frustrating thing about legal writing where you are in your legal education right now?
Hello. I'm on 1L as well. I want to say that the most difficult part for me as we're moving on to the next writing assignment is merging the cases together in the discussion section. I feel like that's kind of difficult, as well as just getting my discussion section flushed out. And I feel like I'm kind of reiterating stuff throughout I just feel like I'm reiterating certain things. How can I make it sound fluent?
Sure. Great question, Jordan. Thank you for that. And let me also just start by saying this is October of your 1L year. I think these are the perfectly developmentally appropriate struggles to be having. The problems are getting more complex as your first 1L semester goes on. And yeah, this is the sort of thing that you begin to struggle with. I would say that there's a fine line between being thorough and being redundant. And there's a fine line between showing off what you know and saying things that are irrelevant, and finding that line is the struggle of 1L year. So I don't have a fantastic, like, simple, here's how you solve this problem issue. I will just first of all acknowledge this is the part of the semester of the year of your legal education where this is the thing that you're grappling with. So on the one hand, I applaud you that this is the trouble that you're having at the moment. I think that, I mean, obviously it's easy for me to say and it's hard for you to do. One of the best things you can do is draft something and then walk away from it for a while and then come back to it to see where the gaps in your logic are, or where you have said the same thing numerous times. Legal writing does expect you to have conclusions all over the place. There's supposed to be conclusions at the beginning of paragraphs, the end of paragraphs, in the headings, in the final conclusion section. The conclusions are everywhere. And we do that in part because legal readers don't always read the whole document beginning to end. So we have to sort of tuck information in. So if a person only reads my A section, will they get all the information that they need out of it? So part of the reason that we're tucking information in all these conclusions is so that each section of the paper can be read independently and still give the reader a lot of value. So so just forcing yourself to write the entire draft out ahead of time and being able to walk away from it for a while and then come back to it, you'll probably be able to see what's redundant and what isn't. Also, I mean, I would try taking individual paragraphs and having others read them to the extent that that's permissible under your professor's rules, just getting other people's feedback. But yeah, this is the struggle. This is the right struggle to be having. I'm glad this is the struggle that you're having.
Thank you very much.
Sure thing. Any other difficult struggles that we're having that we're trying to troubleshoot today I can help with?
I have a question too that I'll ask. It's applicable to me directly. As I'm a 3L as well, as you know, but as I'm getting ready, I'm in the process of applying for jobs. And a lot of times they're asking for like writing samples, right? And I haven't written anything traditionally like a a legal right, like when we write 1L year, like that's all I have as far as that type of writing. Like I've written for 2L, but it's like term papers.
Right.
You know what I mean? Is it sufficient to submit like a paper? Like I've gotten good grades on these papers, but is it sufficient to submit that type of paper for a writing sample? Or should I use something from my 1L year and maybe just beef it up a little bit with some more cases and better analysis when I'm submitting for jobs?
Yeah, I mean, obviously, the first thing to do is to ask the employer that question. What would they rather see? My gut tells me if you're applying, for instance, for a litigation firm or even a transactional firm, the term paper is probably not the kind of legal writing they're most interested in, because that's not the kind of work you'll be doing for them. So I would try to submit a writing sample that's as close to the work product you would be producing in that office as possible. That said, I know you and I have talked about some of your writing samples in the past and how to cut them down. Because like if you write an appellate brief at the end of your first year of law school, it's gigantic and you don't need to submit the whole thing. So you could submit a section of the brief as your writing sample with an offer to provide more if they'd like to see more. But yeah, my instinct tells me that you should submit a writing sample that looks like what they do every day.
Well, if we don't have any more questions, Professor, I'm okay with ending a little bit early if you are as well.
That's absolutely fine. Can I just end by saying legal writing is really difficult. It's hard. It's hard for me. I struggled writing this presentation, trying to put these sentences and paragraphs together to make them as good as possible for you all. And I've been a lawyer for more years than I care to admit right now. So if you're struggling with legal writing, it's not because you're dumb. It's because it's hard. That's the part of the process. So please don't beat yourself up about difficulties that you're having with legal writing. The work is difficult. There's nothing wrong with you. This is hard work, and your perseverance is what is impressive, more so than like the ability to say like, oh yeah, I just dashed it off. It was easy for me. So stick with it. The work is rewarding. It is worth it. And I'm very glad that you are all in law school and on your way to being full members of our profession. Thank you so much for having me today.
I needed to hear that. I appreciate that very much.
Yeah, we did. Thank you so much.
You're very welcome. Delighted to be here. Thanks for having me.
Thank you. Quick question. Is this recorded? Can you send this to us, email it, or how can we get this?
Or your PowerPoint even?
Oh, yeah.
I can, if you send me the PowerPoint, Professor, I'll send that out. And then this is going to be recorded. It's going to be on the SWBLSA YouTube page, and we'll post about it on Instagram, and it'll be in our newsletter as well.
Perfect.
Awesome. Thank you, guys.
Thanks
You're very
again.
welcome.
Have a nice evening.
Of course. Take care.
Thanks so much. I think that went really well. Let me stop recording.